this is America. Don't catch you slipping now.
Hey, what's up, peoples? Thanks for tuning in. We are continuing with how to file a criminal complaint in the criminal court under CPL, Criminal Procedure Law, section Article 100, under subsection 100.10, local criminal court and youth. Part of the Superior Court accusatory instruments, definitions thereof. Now, here are the definitions. So we're going to go over the first one. An information is a verified written accusation by a person filed with the local criminal court, charging one or more other persons with the commission of one or more offenses, none of which is a felony. It may serve as a basis for the commencement of a criminal action and for the prosecution thereof in a local criminal court. Now, this is a way for the courts to try to charge individuals with infractions, which it doesn't say here, but from my experience, when I get charged with infractions, they file it under this section of the criminal code, when actually they shouldn't be filed at all under the criminal code. Because usually when I get charged with like something like possession of marijuana, obstruction of governmental operations, for not IDing, when they try to charge me with something simple like disorderly conduct, where there isn't actually anybody accusing me of disorderly conduct or of that nature. It's actually a government official who initiates the complaint, when the government official isn't supposed to initiate a complaint when you're exercising a First Amendment right, like cursing or saying things that someone doesn't agree with, or recording in public, and since the officer says you fail to ID for this civil infraction, which has no actual merit behind it because it's a government official charging you with these civil infractions, and they try to turn it into the criminal side of the spectrum when you fail to ID. And when we went over the Right to Know Act, that only time you have a obligation to ID is when you're being accused of a crime or being believed that you've committed a crime or an act of a crime. So that's the only time you have the obligation to ID. Now, for civil infractions like urinating in public, possession of marijuana, government obstruction, well, that's part of the criminal part, when they try to say you obstructed them from not giving ID. But when you challenge a court and you challenge jurisdiction of the court to hear said infraction, and you want to be indicted, which is your right under the New York State Constitution, that all criminal cases, defendants have a right to be indicted. So my way to getting around being charged with a local information, which they always do, is demand to be charged, to be indicted. So the only issue with that is you can't be indicted on a civil infraction. So they will never get an indictment when you put it in writing, when you put it in your motion, and you also say it in the court verbally that you wish to be indicted and you're not waiving that right. And the court actually requires you to sign a waiver. So that waiver isn't there saying that you waive your right to indictment. They can't proceed. So they'll make you keep coming back to court when they should have dismissed it right off the first date when they see they have no jurisdiction to go forward. But they continue to have you return to the court in hopes that you'll settle out, or get discouraged, and they try to use a lot of intimidation tactics. Like when I first went to court and I challenged the jurisdiction of the court, they decided to pile on more charges and try to intimidate me more that way. And I didn't budge. I said, okay, you want to charge me some more? But I'm going to ask for indictments on those charges too. So they will never ever get an indictment on those charges. And because it's not a criminal charge, what they're charging you with. They're charging you with policy violations, civil infractions. So you have no obligation, according to the Right to Know Act, you have no obligation to identify to police for a civil infraction. And then they try to say you're obstruction, and then obstructing, which they try to convert it into a criminal offense. So we guess instead of going to a civil court, it goes to a criminal court. This court right here, which it mentions local criminal court in the information part. Now, my bad. The simple traffic information is another type of accusatory instrument where individuals can be charged. But we're going to go into that next video and go into more definition. I'll go read into that. Now, I provided the links down low, and you can research yourself, get yourself a law dictionary, a Black's Law Dictionary, a Bouvier Law Dictionary, Valentine's Law Dictionary. They're all great to have, or you could look on them online. They're available online, and it's good to cross-reference definitions to make sure you're getting an understanding of what you're reading if you don't understand a certain word, because these individuals do have their own language. It's known as legalese. Now, the best way to learn their language is to study it. So do yourself a favor and study their language so you can understand better when they try to how can I say it? Disguise their language with regular English. It is English, but the definitions are so convoluted and so entrenched with, how can I put it? They're just not words which you think they mean when they mean something else, like a synonym, right? I think that's a synonym. But anyways, check this out and just study up some more, and I'll see you next video. The link is down below, and have a good day. And remember, education is key to keeping you free. All right, have a good day.